The notary stamped 4 documents that afternoon. My sister signed each one with the confident flourish of someone who had been rehearsing that signature in her mind for years. My parents sat beside her at the dining room table, smiling the particular smile of people fulfilling a plan they had been quietly building for a long time. I sat across from all 3 of them, holding a glass of water and saying nothing. Nobody asked me to sign anything. Nobody explained why I was there. I think they invited me because leaving me out entirely would have looked too obvious even for them. My name is Nadia Osei. I am 35 years old, and until that Wednesday afternoon in September I believed my grandfather had loved all of his grandchildren equally. He had certainly treated us that way. Every birthday remembered. Every achievement acknowledged. Every conversation given his full attention regardless of who was speaking. What I did not know yet was that equal love and equal trust were 2 entirely different things in my grandfather's careful accounting. And that the difference between those 2 things was sitting in a filing cabinet 40 minutes away, unsigned, waiting for exactly this moment. My grandfather, Samuel Osei, had spent 40 years building a modest but solid real estate portfolio in Columbus, Ohio. 6 residential rental properties, nothing glamorous, 2-bedroom houses on quiet streets that he had purchased one at a time across 4 decades of careful saving and patient management. He maintained them himself well into his 70s. He knew every tenant by name. He kept every lease, every repair receipt, and every payment record in color-coded binders that lined an entire shelf in his home office. He died 18 months ago at 81, quietly, in his own bed, the way he had always said he wanted to go. My sister Amara was 29, 3 years younger than me, and had spent the better part of our adult lives positioning herself as the responsible one in our parents' eyes. She called more often. She attended every family event without complaint. She remembered our mother's preferences and our father's opinions and repeated both back to them at strategic moments. I loved my sister. That matters to say plainly because what follows is not a story about hatred. But I also understood what she was doing in a way our parents never quite did. Amara collected goodwill the way some people collect insurance. Steadily, consistently, with one eye always on the future payout. I had watched it for years without comment because pointing it out would have made me look jealous, and I refused to perform jealousy for an audience that had already decided the narrative. The Wednesday afternoon with the notary came 6 weeks after my grandfather's estate had cleared probate. My parents had been named co-executors and had spent those 6 weeks handling the distribution quietly and without much family discussion. When my mother called to say they wanted me present for the formal signing, I had assumed it meant I was receiving something. I understood my mistake within 30 seconds of sitting down. The 4 documents were deed transfers. All 6 rental properties divided into 2 groups and transferred to Amara through a legal structure my parents had apparently arranged with an estate attorney named Franklin Carr, whose business card sat beside the notary's stamp pad. I watched Amara sign her name 4 times. My parents signed as co-executors. The notary stamped everything with the mechanical efficiency of someone who processes other people's significant moments as routine. Then my mother looked at me with an expression that was trying to be gentle and landing somewhere closer to apologetic. "Your grandfather left you his personal items," she said. "The books, the watches, his Bible." I looked at her steadily. "And the properties?" She glanced at my father. He cleared his throat. "Amara is in a position to manage them properly," he said. "She has the time and the focus." We felt this was what Samuel would have wanted. I noted that he said felt rather than knew. I picked up my water glass and took a slow sip and thought about my grandfather's home office and the color-coded binders on the shelf and the conversations we used to have on his back porch on Sunday afternoons when I would drive over to help him with his bookkeeping. I thought about the last Sunday afternoon specifically. 8 days before he died. I thought about what he had handed me across the porch table and what he had said when he did. I set my glass down carefully. "Congratulations, Amara," I said. Then I drove home. I pulled into my driveway at 6 p.m. and sat in the car for 10 minutes before going inside. Not falling apart. Thinking. There is a difference, and the difference matters, especially in moments like that one when the emotional and the practical are both competing for the same mental space. My grandfather had handed me a document on that last Sunday afternoon. A transfer of management authority form, the kind used in Ohio to designate a property manager with full operational control over a real estate asset. It covered a single property, the smallest one in his portfolio, a two-bedroom house on Clement Avenue that he had owned for 22 years and considered his original investment, the one that had made everything else possible. He had filled it out completely in his careful handwriting. My name in the designated manager field. His signature on the first line. His address and property details all present and correct. But the form required two signatures. His and a witness. The witness line was blank. He had handed it to me across the porch table and said, "I need one more thing from you, Nadia." Not yet. But soon. Keep this safe until I tell you it is time. 8 days later he was gone. I had kept the document in the fireproof box under my bed where I kept every important paper in my life. I had not told anyone about it because he had asked me to wait, and I had decided to honor that even without understanding it fully. Sitting in my car in my driveway after watching my sister sign 4 notarized deed transfers, I began to understand it very clearly. He had known something was coming. He had prepared me for it in the only way available to him. And he had left one thread deliberately unfinished for a reason I needed to figure out before I could pull it. I went inside and called my cousin Dara, who had been an estate paralegal in Cincinnati for 8 years. Dara listened to everything without interrupting. Then she asked me to photograph the document and send it to her immediately. I did. She called back in 20 minutes. The transfer of management authority form was valid under Ohio property law with one witness signature, she said. Without it, the form was incomplete but not void. The property itself had been included in the estate distribution my parents had arranged. But management authority and ownership were legally distinct categories. If I obtained a valid witness signature confirming my grandfather's signature on the form, the management authority clause would activate. It would not override the deed transfer my parents had arranged. But it would give me documented legal standing to contest the distribution on the grounds that my grandfather had expressed a conflicting intent regarding at least one property in the days immediately before his death. More importantly, she said, it would require the estate to be reviewed by a probate court before the deed transfers could be recorded as final. I asked her what that meant practically. It means the process pauses, she said. And when it pauses, a judge looks at everything, including any other evidence of your grandfather's intentions. I thought about the color-coded binders on his shelf. I thought about 8 years of Sunday afternoon bookkeeping sessions. I thought about every lease renewal and repair authorization I had helped him process while Amara was attending family dinners and collecting goodwill. I asked Dara one more question. Who could legally witness a signature already made if the original signer was deceased? She explained the process carefully. A handwriting expert could authenticate my grandfather's signature. A sworn affidavit from someone present when he signed could serve as supporting testimony. And if the form could be shown to have been prepared and signed in the presence of a witness who simply had not yet added their own signature before the signer passed, that witness could still complete the form legally. I sat very still for a moment. Then I remembered something. My grandfather's neighbor, a retired schoolteacher named Constance Boateng, had been sitting on her porch the Sunday afternoon he handed me the document. She had waved at us from across the fence. She had been there the entire time. I called Constance at 8 p.m. She picked up on the second ring. Constance remembered the afternoon clearly. She remembered seeing Samuel at his porch table with papers. She remembered seeing me arrive and sit across from him. She remembered him handing something to me because she had thought at the time that it looked like something important passing between two people who understood each other. She had not been formally asked to witness anything. But she had been present, she had observed, and she was willing to provide a sworn affidavit confirming what she had seen. Dara filed the legal challenge the following Thursday morning. The probate court issued a review order 3 days later, which automatically paused the recording of the deed transfers my parents had notarized. Franklin Carr called me that Friday afternoon. His tone was professional but careful, the tone of an attorney who had just realized the situation was more complicated than his client had indicated. I referred him to Dara and ended the call. My mother called an hour later. Her voice was the careful version, the one she used when she wanted to have a conversation without having a confrontation. "Nadia," she said. "What is this about a court order?" I told her calmly and completely. The document. The Sunday afternoon. Constance. The witness affidavit. The management authority clause. All of it in plain language without anger and without performance. The line was quiet for a long time. "Your grandfather gave you that," she said finally. It was not quite a question. 8 days before he died, I said. Another long silence. "He never told us," she said quietly. "I know," I said. "He told me to wait until it was time." I waited. The probate review took 6 weeks. The judge examined the management authority form, Constance's affidavit, and the handwriting authentication Dara had commissioned. He also examined 8 years of bookkeeping records that my grandfather had kept, records that showed my name on every major management decision for the Clement Avenue property and 3 others going back to when I was 27. The judge's ruling did not overturn the deed transfers entirely. Amara retained ownership of 4 properties. But the Clement Avenue property was ruled to have had a documented conflicting management intent established by my grandfather in the days before his death. Combined with the management records showing my sustained involvement, the judge restructured the distribution. Clement Avenue transferred to me in full ownership. 1 additional property was placed in a shared trust between Amara and me with equal decision-making authority. My parents said very little at the hearing. My father looked at the management records, 8 years of Sunday afternoons represented in organized columns of figures, and I watched something move across his face that was not quite guilt and not quite pride but lived somewhere honestly between the two. After the hearing, Amara and I sat in the courthouse parking lot for 20 minutes. Not arguing. Just sitting with the truth of it. She asked me why Grandpa had done it this way. Why not simply tell everyone? Why the unsigned form and the instruction to wait? I thought about his porch. His careful handwriting. The color-coded binders. 40 years of patient, methodical building. Because he knew, I said. He knew what was being planned, and he knew that the only thing that would hold up was documentation. Not conversations. Not feelings. Paper. Amara was quiet for a moment. That sounds exactly like him, she said. It did. That was the thing about my grandfather that his Sunday afternoon lessons had taught me more thoroughly than anything else. He never raised his voice. He never made accusations. He simply kept meticulous records and trusted that the truth, given the right document and enough patience, would always find its own way to the surface. He had been right about that his entire life. He was right about it one final time on a Sunday afternoon 8 days before he left us, when he handed me an unsigned form across a porch table and asked me to keep it safe until the time was right. I had kept it safe. The time had arrived on its own, exactly as he always said the truth eventually would.